Decasa members, this is once again Vanessa Jost from Decasa, and we're quickly going to talk about when a consumer can exit debt review process. So when a person applied for debt review, we talked about that, and before a declaration, a 17.2B declaration, a person can withdraw from debt review. They can just send an email and hopefully try and get that always in writing to say that a person has they don't want to proceed with debt review anymore. Then they can with ease just be removed from debt review. So once a 17.2B declaration has been made, you've declared the consumer over indebted. There's no way that you can just withdraw them from debt review. Okay, so we're going to look at the time period with a 17.2B over indebted declaration has been made, but before a debt review court order, tribunal order has been obtained. So if your consumer comes to you and tells you, Mr. I've just received a huge increase from my work, or I've a bonus or whatever that may be, and I'm now in a good financial standing, I can actually pay up all my arrears, and I can, from today onwards, I can pay up the original credit agreement installments. There's no court order yet. Then your application goes to the court, and the consumer will bring additional facts and evidence to say to the court, hey, look here, I can actually afford my credit agreement now. It will be original facts, probably be a supplementary affidavit that you will bring from the consumer side to say that the circumstances has changed. The magistrate court will look at the application and then probably declare the person to be not over indebted. So now I just quickly want to clarify something. Many people still refer to a no longer over indebtedness application, which is not the case. The Magistrates Court or the National Credit Act actually does not have jurisdiction to bring a no longer over indebted application. If you look at the sections in the Act in the debt review, so only you can go for no not over indebted if there's no court order, magistrate court order yet. So once that has been done, and if you've received that court order, you will change your consumer status on DHS to G1, to not over indebted. The Debt Counsel will then send out a Form 17WC Annexure A to accompany the order of court to credit providers where the magistrate court has found the consumer not to be over indebted. You will probably ask or charge your consumer debt counselling fees in line with the NCR debt counselling fee guidelines applicable from time to time and up until where you have worked. So that is the case where a person has been declared over indebted by 17.2B and there's no court order yet. Then they can bring additional facts to the court. I'm also referring to the Janssen van Vuuren judgment. I'll put a link on this video or on top of the comment section so you can just go and have a look at the full court application or court order, and that is what we follow at the moment, because that court application actually nicely explained to say that a magistrate's court does not have more powers than what are bestowed upon them in terms of the Act. So the Act doesn't give you a right to apply for debt review and just bring a no longer over indebted application. We can only go according to the Act. So all these debt counsellors or rogue debt counsellors and attorney firms that have these advertisers say, I can get you cleared from debt review now, you just pay a few $1,000. It doesn't work like that. It should be a proper procedure that needs to be brought to court with the correct facts and circumstances. So I hope that helps. If you've got anything that I need to clarify for you or additional comments or anything, please contact me or phone me and we can discuss this matter. I hope that helped.